is Leona Bennett, and I am one of the partners here at Southern Waters Legal and the head of the family law team. I'm here with Laura Tilt from my team, and we're running our segment on some frequently asked questions in family law. So one of the questions we do get asked quite a lot is, what does the court consider in making arrangements for the children post-separation?
Yes, so the primary consideration of the court, or I guess the crux of what the legislation says, is what is in the best interests of the child or the children. And the way in which the court considers that or decides what is in the child or the children's best interests are primarily two main considerations. One is the importance of the child or the children having a meaningful relationship with both parents. Mm-hmm. And the second is the importance of protecting the child or the children for any harm or exposure to family violence.
Yeah, so it's a real juggle across those two big umbrella considerations. You talked about them being the primary considerations. So I take it then there's some additional considerations that get considered as part of the whole process?
Yes, definitely. So the section in the legislation, which is section 60cc of the Family Law Act, it's got those two primary considerations, and then the rest of the provision looks at all of these different issues that a court might take into account when they're considering what's in the child's or the children's best interests. Some of those, for example, can be the views of the child, and the weight that's held on that depends on the child or the children's ages. So, of course, the older they get, the more important their views become.
And their maturity, how mature they are in expressing those views, yeah?
Definitely. Some other considerations are the nature of the relationship that the child or the children has with both parents, and the extent to which each parent has gone to spend time with the child, to make decisions for the child or the children, and that sort of thing. There's also the sort of reasonable practicalities of living with one parent and spending time with another. So if one parent, for example, is in a different state or a different country, then of course that will be considered as to how much time the children spend with that parent.
And one of the things that we still hear quite a lot is people saying, I want full custody of my children, or I want access of my children. That's not the language that's used now, and it changed many years ago, but it doesn't mean that we still don't hear it a lot come across in layman's terms. So what does the court talk about now when they talk about the old version of custody and access?
Yeah, so now it's really live with, spend time with. So who's the child going to live with, and then how much time is going to be spent with the other parent that they may not live with. And so they're the terms that we now hear in a court.
Okay, perfect. Well, thank you very much. That's really informative, and I think anything that gives people the knowledge to make decisions about what's going to happen next with their children only assists them in this separation process. So if we can assist you with anything to deal with your post-separation arrangements with the children, or if it relates to your property settlement and you require our assistance, please don't hesitate to give us a call. We're really happy to help. Thank you.